The Geneva Convention of 1927 on the recognition and enforcement of arbitration awards is the ancestor of the most successful agreement ever entered into in the era of private law, the New York Convention on the recognition and enforcement of arbitration awards. If you want to understand the New York Convention, you have to understand the Geneva Convention. The New York Convention was put together to fix a number of the problems with the Geneva Convention. And after all, for countries that didn't ratify the New York Convention until relatively recently, if they had been members or ratifying countries of the Geneva Convention, this was the law in their states. And as conventions go, it's not a bad effort. It did have its problems. These were outlined in a number of publications at the beginning of the Second World War, one notably by Arthur Nussbaum, who bemoaned the destruction of what he earlier described as the arbitration movement as a result of a variety of things, but notably various countries' misinterpretations of the 1927 convention. So we better actually have a look at the real text itself and take it apart. And it's vitally important in this respect that we don't lose track of what the convention actually says, rather than what various countries have described it as saying. Here is the document, and you'll see straight away in Article 1 that the awards that are covered are those picked up by the Geneva Protocol. And the Geneva Protocol actually only applied where the parties were subject to the jurisdiction of a contracting state. So Article 1 starts off by saying that an arbitral award made pursuant to one of these protocol agreements are recognized as binding and shall be enforced in accordance with the rules of the procedure of the place they're relied upon. Okay, as long as the award, though, was made also in a territory of one of the contracting states, which is an added complication. So not only have you, the parties, got to be subject to one of the contracting parties' jurisdiction, so must the seat of arbitration. And that builds in effect, a reciprocity reservation, but makes it, which you'll find in Article 1 of the New York Convention, but it makes that reservation part of the convention, which is a pain. So in order to obtain recognition or enforcement of the award, you have to show that the award's been made pursuant to an arbitration agreement valid under the law applicable thereto. No private international law provision it appears here. You have to kind of work it out. And presumably the conflict of laws rules in question are the laws of the place of enforcement, which may not be ideal. Second of all, the award has to be based on the subject matter that's arbitrable in the place of enforcement. That's found actually in Article 5.2 of the New York Convention. The slight difference here being that it's the claimant or who is seeking enforcement that's got to prove these elements. It's also got to show that the award was made provided for in the submission, the tribunal provided for in the submission to arbitration, and put together in the way agreed upon by the parties and in conformity with the law governing the arbitration procedure. As with the protocol, there is the problem ultimately dealt with in the New York Convention of working out what to do if the manner agreed upon by the parties does not conform with the law governing the arbitration procedure. And the most crucially of all, Article 1D required that the award must be proved to have become final in its seat of arbitration, not open to any sort of challenge, or if it is proved that any proceedings for the purpose of contesting the award, validity of the award are pending, you're in trouble. So the award has to be final, and this generated the legendary double exequatur problem. It's not actually what Article 1D requires. There's no obligation to seek an enforcement order in the seat of arbitration before you can say you've complied with Article 1D. You've just got to show that there is no possibility of any appeal or setting aside proceedings being brought against the award. Even that, though, creates a time lag problem. And finally, that you have to prove the recognition enforcement is not contrary to public policy or the principles of the law of the country of enforcement. It's a very odd statement, and it's very difficult to know exactly what those principles are. Public policy, of course, remains a defense to enforcement in Article 5(2) of the New York Convention. Even then, if the provisions laid down in Article 1 are met, you can still get your recognition and enforcement refused if the court is satisfied of certain items. It's not explained in Article 2 who's got the burden of proof of these elements. Notably, the award's been annulled in the country in which it was made. That's Article 5(1)(e) of the New York Convention. Failure to give appropriate notice, which is reasonably sensible, and the defendant being under legal incapacity, not being properly represented. You can understand that. That's found in Article 5(1)(d) of the New York Convention. Similarly, the award doesn't pick up a point or dispute covered by the agreement, should be falling within the terms of the submission, or it deals with decisions going beyond the scope of the submission to arbitration. Note the difference between the submission to arbitration and the arbitration agreement. Parties, as part of the arbitration process, or the pleading process you could call it, indicate what's within the submission and what is not. And Article 5(1)(c) of the New York Convention provides a defense to enforcement there. You can actually, as an enforcing court under Article 2, delay recognition and enforcement or provide any guarantee if an award hasn't picked up everything submitted to the arbitration tribunal. It allows the arbitration tribunal to look at the extra elements that have not been covered in the award. Then Article 3 allows the defendant to prove that under the law governing the arbitration procedure, there is another ground entitling him to contest the validity of the award in a court of law, even though such a proceeding has not actually taken place or been brought. The court then is entitled to refuse recognition or enforcement or adjourn to give the party wishing to challenge the validity of the award, in reality the respondent or defendant, a reasonable time to have the award annulled. If you are going to try and seek enforcement, Article 4 matches Article 4 of the New York Convention, requiring delivery of the original award or a copy duly authenticated, and any evidence that any of the Article 1, Paragraph 1 and 2A and C conditions have been met. The difference here is that Article 4(2) requires documentary or other evidence to prove that the award has become final in the seat of arbitration, and that's where the double exequatur problem comes in, again, in effect. We can leave aside the translation requirements, but Article 5 is the equivalent of Article 7 of the New York Convention, or Article 7(1), in that any interested party is entitled to rely on an arbitration award if the laws or treaties of the country where the award is sought to be relied upon allow it, even if there would be a defense to enforcement under the Geneva Convention. And finally, there is a time issue here that the convention only applies to awards made after the entry into force of the Geneva Protocol. Beyond that, well, that's the convention. You can see what the problem is. The party trying to enforce the award is required to prove a whole lot of things, which doesn't help, but above all else, they have to show that the award is final in the sense that it cannot be challenged, and that it is not subject to any pending challenge. That did cause problems. These are the two issues that were subsequently under discussion in the New York Convention. The other element is this problem found also in the protocol, whereby submissions to arbitration must be valid both under the law of applicable to the agreement, but also to the parties' agreement, and that's not helpful when the two fall into conflict. And the same applies to procedure. So the Geneva Convention ultimately failed because it didn't get enough ratified countries. If you don't have enough contracting states, you don't have an effective agreement. And it was the failure to collect those ratifications which ultimately led the ICC to propose a new convention after the Second World War, and led in the end to the New York Convention on the Recognition and Enforcement of Arbitration Awards. One element you might like to note is that there is no formal validity requirements under the 1927 Convention, or indeed the 1923 Protocol. This is all to be dealt with as a matter of the law governing the arbitration agreement. So, for example, Article 1A requires the complainant or claimant to show that the award's been made in pursuance of a submission to arbitration valid under the law applicable thereto. That itself creates a private international law problem, and I suppose one should be realistic enough to note that in 1927, many countries had quite strict formal validity requirements, but not all. English law in the 1920s, governed by the 1889 Arbitration Act, only required there to be a document to which the parties had agreed, not necessarily in writing, for there to be a formally valid arbitration agreement. And so in this respect, Article 2.2 of the New York Convention actually restricts the number of awards that can be enforced. However, both the 27 Convention and the 1958 one allow parties to rely on the law of the place of enforcement, here under Article 5 of the Geneva Convention, Article 7 of the New York Convention. That is where the place of enforcement would enforce the award, even if under the convention it would not be enforceable. I hope you found this of interest. It is a vitally important document. Thank you.